Opponents of litigation funding are primarily concerned with the need to protect the purity of justice by preventing third parties from manipulating the litigation process. The U.S. Chamber Institute for Legal Reform (ILR) has identified 4 negative public policy consequences of third-party funding. First, third-party investments in litigation can increase the volume of abusive litigation because the funders can hedge any investment against their entire portfolio of cases. Second, it can undercut the parties' and lawyers' control over litigation because the funders can be expected to try to exert control over strategic decisions. Third, it can prolong litigation by making reasonable settlement offers less attractive because of the investors' extra demand on a share of the proceeds. Lastly, third-party investments can compromise the attorney-client relationship and diminish the professional independence of attorneys by injecting a third party into disputes. However, proponents of litigation funding highlight the fact that third-party funding has the ability to provide access to justice for under-resourced parties, which enables them to pursue legal proceedings that a lack of funding would have otherwise prevented. One U.S. district court acknowledged that costs inherent in major litigation can impair a plaintiff who lacks resources to sustain a long fight. Furthermore, funding advocates counter critics by noting that funders wanting to stay in business will not risk their investment in frivolous matters. Additionally, financial investors urge that ultimate decisions regarding settlement and legal strategy are always in the hands of the plaintiff and lawyer. Nonetheless, third-party funding does come at a cost. If a plaintiff is successful, the funder will collect a portion of the settlement. Nevertheless, if a plaintiff would otherwise be unable to pursue legal proceedings without funding from a third party, then a funder's recovery of a portion of its claim is better than nothing.